Welcome to today's webinar. Today we'll be talking about compliance issues for California employers. This includes pay for employees with COVID-19, vaccinations, notices to employees, and testing for COVID-19. My name is Jake, and I'm part of the team here at CalWorks Safety and HR. As always, our goal is to provide current information with the understanding that this could change in the future. We will continue to give you access to new webinars as we have updated information, so be sure to look for our email updates. Before we begin, I would like to remind our attendees that you are in listen-only mode. If you have questions during the webinar, please feel free to utilize the chat box to ask your questions, and our speaker will try to answer as many as they can during the last 10-15 minutes of the webinar. I will be helping to facilitate your questions. If we do not address your questions today, or you would like to receive a copy of all the slides presented to you, send us a note at info@calworkssafetyhr.com, and we'll help you out within 24 hours following the webinar. Now, there's a lot of information to cover, so let's try and hold those questions until the end, as we may address them during the presentation. Now, I would like to introduce our speaker for the day. Dawn Dressler is a founder and managing partner of CalWorks Safety and HR. Dawn is a practicing attorney specializing in employment law and human resources issues, and consults on insurance and risk management issues for private companies and trade associations. Dressler is a frequent speaker on workers' compensation, health insurance, human resources, and organizational development issues. Please welcome Dawn.
Good morning, everyone. Today, we're going to try and update you on major areas for human resources compliance for 2021. We're going to begin with the rules and developments regarding COVID-19, because this has been one of the most important areas for our clients, sources of questions and difficulty to keep up, changes coming regularly. And I think it's fair to say now, with the new administration in Washington, there would be even more new rules and guidance. New head of the CDC was appointed to just now. So this is an area that you need to know about. We're also going to cover some other areas that go into effect or are applicable in 2021, just so everybody is aware of and on top of what they need to do. So we'll talk about minimum wage and independent contractor status and the expansion of the California Family Rights Act, which is a major issue for any employers that have between 5 and 50 employees, because this is now a law that applies to employers with less than 50 employees, which is a change from prior law. As in many areas of both COVID and employment law, they are frequent and conflicting changes and different entities giving directions. Today's presentation is up to date as far as possible, but you need to keep your eye out for changes, and we'll of course try to inform you about changes of rules as well, so that everyone is able to do the best they can to comply with the law. So one of the developments of COVID-19 is if you have an employee who cannot work because they developed a positive test for COVID or are ordered to be quarantined, and they obtain the disease from work, this is a big qualifier, the Cal/OSHA emergency regulations, which went into effect December 1st, require you to pay that employee in some form. But how are you to do it? Well, one of the sources of payment in the past has been one of the first federal laws enacted during the COVID crisis last March, which was what we call the Families First Coronavirus Response Act, or FFCRA. That law created an obligation for employers of less than 500 employees to provide emergency sick leave pay for up to 10 days for people who had been tested positive for COVID. That law, however, expired on December 31st of 2020. So it's not a mandate any longer. However, employers because of the emergency COVID response enacted at the end of December of 2020, employers can voluntarily continue to use the provisions of FFCRA until March 31, 2021. So if under the Cal OSHA rules you must pay an employee, you can use the FFCRA for up to 10 days of pay. And a couple of caveats there. If you use the FFCRA, you can get reimbursed out of your federal payroll taxes so that you get the money back. But when the Congress made the change at the end of last year, which let employers choose or voluntarily have access to this benefit, they did not add numbers of days. So it's been now 10 months or more since many employers have been dealing with the COVID situation. And it's entirely possible that you've had employees who sometime earlier in 2020 had time that was paid under this emergency sick leave provision. The change in Congress doesn't add more time. It just says you have more time to use the 10 days that are available. So there's no restart on the calculation number of days. The limit is still 10 days maximum per employee from March 2020 until March 2021. So this is part of the Cal OSHA emergency standard. Employer must continue to provide employees pay and benefits if the employee is able and available to work. This means if an employee was exposed through work-related activity to a COVID case as a close contact, even if they remain asymptomatic, the employer must provide their pay and benefits. However, in a ruling on January 8th, Cal OSHA said if an employee is unable to work because they have COVID symptoms, they're not considered able and available to work. Therefore, they're not available to the exclusion pay and benefits. Now, the irony of this is, of course, about the time the person needs it most, Cal OSHA says they're not required to do it. However, there are other benefits available to an employee, and they are state disability insurance, your own company's paid sick leave policies, vacation pay, and perhaps family leave pay under EDD's rules. Now, the good news is Cal OSHA has announced that on its rules, which include a number of things we'll talk about this morning, if you make a good faith effort to comply, there will not be any monetary penalties for inspections until after February 1, 2021. So January is the time for you to make sure you understand what the Cal OSHA rules are and that you're in compliance. You need to be able to show good faith efforts of compliance, which means doing something. And it doesn't involve a violation of your written safety plan. There's some other rules. It's just the COVID plan. And of course, you must fix any violation. And there's no imminent hazard, but most of the Cal OSHA COVID cases we've seen do not involve imminent hazard. Realize also, though, even though there are these changes at the state level and the federal level, there are still local employment paid sick leave laws, such as Long Beach, City of Los Angeles. They're considering hero pay in Los Angeles, although I don't know if they'll go forward with that. And there's local EPLSI benefits that have been extended in Sacramento City and San Francisco, San Mateo, San Jose, and there continue to be various cities who their local city council or county supervisors who extended. So this is an area that becomes always an issue, trying to keep up to date with the ordinances in your own area where your employees work or you have your offices. One of the questions that we've encountered, and we hope that we are able to deal with soon, is the issue of employers having a policy requiring employees to obtain a vaccination. This has changed a little bit over the last couple of months, but now it is clear that you can require employees, when available, to obtain a vaccination for COVID. It must be at the employer's expense for the cost of the vaccination and the time to take it. However, there are sources of free vaccine if you keep in touch with your local public health agency to get guidance for that. There's one limitation on it. If you have an employee who has a disability, meaning severe allergies and so on, who then are not able to take a vaccine, you need to have an interactive process and discuss accommodation processes with them. However, I will say fear of vaccine is not a condition. It does not excuse an employee from complying with employer rules. Another issue are masks. During the current stay-at-home order, everyone is required to wear masks when not in their own personal dwelling. The exceptions are when in a closed room or when driving alone. It's really critical that you have a mask policy and you apply it to your employees. And realize the requirement to wear a mask applies even when people are more than 6 feet or more apart, because that's not an exception to the requirement to wear a mask. Also, if you have cubicles and you put up partitions, that isn't a excuse for wearing a mask. If you're in a room where you can close the door and air doesn't circulate, or you're alone in a car, that's the only times under the current state orders that people do not need to wear a mask. And considering all of the Cal OSHA requirements and the risk of being charged with operating a serious and willful unsafe location, you really need to take the mask policy seriously. The good news is it looks like we've reached the peak of local infestations or infections here in the Southern California area, although it hasn't declined to any significant amount. So we're going to continue to have very serious spread of COVID, at least for the next 6 weeks or so, and as long as it takes until there's a widespread use of vaccine. So this is not something that's going to be over at the end of January. The Cal OSHA requirements are that you conduct a hazard inspection. And this means that you have to record how you checked your property. Many employers now have done this, but they're still, I'm learning, many who have not. And one of the Cal OSHA rules is you include employees in the process. As a result of that hazard inspection, you need to have a written COVID-19 prevention plan. And it should be done now, with the exception for employees who are working from home, but that means all of your employees are working from home. Since we have a provision that says you will not be given a citation if this is done before February 1, you should use the next 10 days or so if you haven't already gotten a written COVID plan. The other part is if you wrote a COVID plan before December 1 of 2020, odds are it does not have all of the required elements that the Cal OSHA emergency rule applies, because all of us who are working on COVID plans in the spring and summer of 2020 didn't have the elements that were required as part of the Cal OSHA regulation. Now let's go through some important definitions. Who is a COVID case? Because this is a part that triggers a lot of the obligations under the law. A COVID case is a person who has tested positive for COVID or is subject to a COVID-related order to isolate by a local or state health official. So generally, we would suggest that you ask people for COVID test results. Unlike vaccines, where you can require a person to vaccinate, the law is that you can't require a person to take a COVID test. But because of the public health emergency and the danger to your workforce, it's a reasonable request that you ask. And if an employee has exhibited any symptoms, and you should have a check-in daily process, do you check to ask them questions about whether they have temperature, whether they've felt any of the COVID symptoms. If they have, then you should direct them to medical attention before you're allowed to have them come to work. Once a doctor or licensed healthcare professional determines a person does not have COVID, they're no longer considered a COVID case. So you don't have to test negative to become a former COVID case. You have to comply with whatever the doctor has determined. What about excluding people from your workplace? Well, there are two sets of people that we're dealing with. First, those who have COVID symptoms, fever, etc. For those folks, the exclusion period from the workplace or the risk area is 2 days before they first develop symptoms, which you won't know until after they develop symptoms. And 10 days after the symptoms first appeared and they've gone 24 hours without fever, without medicine. The other group of people, which is quite common, and our clients we found is 30 to 40% of the people involved who may test positive for COVID, but never develop COVID symptoms. So for them, the risk period is 2 days before until 10 days after their first positive test for COVID. And I know this gets very confusing, which is one of the reasons we want to do this workshop, because the important thing is the incidence in our experience, especially in LA, Orange, Riverside counties, has been a rapid expansion. Most employers who had never had problems with employees testing positive are now finding that they have one or two more, some multiple people in their workforce who are testing positive or becoming ill. We are kind of at the peak of this crisis. And although it may not be getting worse right now, it could, and it is particularly going to be a dangerous situation for months to come. What is the area of exposure or risk? So a area for exposure for risk is any work location or common area where the COVID person was, and the exposed workplace covers the areas of the building that they were present during this high risk period, which is the 10 days essentially between symptoms and afterwards. The ruling has come down that if you're simply in an area for seconds, like walking up a stairway or walking down a hallway and are not regularly there or walking there often every day, those are not considered workplaces. We don't quite use the 15 minutes in every 24 hours rule for contact, but common sense will help you know which areas are what we call exposed workplaces. And this becomes important because it involves notice to employees and information for them. So once you learn of a COVID case, you have a duty under the Cal OSHA rules to do an investigation, which means essentially how did they get the disease? And in my experience, it means basically asking the 5W questions: who, what, when, where, and how, because the decision you need to know this, and also you're trying to determine whether it was work related or not. So many times, many of our clients have had employees who tested positive for COVID, but who have spouses, children, family members that they've been with who are testing positive, girlfriends, one case even a girlfriend's child who was positive, who then caused the question at the workplace. But you need to know this, so you need to know, because some of your obligations don't apply if the COVID infection comes outside of the workplace. Once you know how they got it, and if it was particularly exposure to people in your workplace, you need to find out who they were in contact with and check their attendance records, whatever, because you have some duties to inform those people that they've been in contact with. So there's several levels of notice. One level of notice is to everybody in a building or workplace where someone is tested positive and reports it to you for COVID. And in that case, you have a duty to notify your employees of when the exposure occurred, where, and what their benefits are, how you clean, how you return to work, and the symptoms of the virus. And also not retaliate. We suggest that you'd have a prepared notice ready to use. And if you need one, you can contact your CalWorks safety consultant and we can help you with some draft notices. This is not something you want to have to run around and do at the last moment. You're required to provide notice within 1 business day of receiving notice of a potential exposure. And the fine is for $10,000, so it's not worth the hassle. Then we have what we call mass exposures or outbreaks. And this is when 3 or more people living not together in your workplace within a 14-day period report COVID. At that point, you need to provide, in addition to the notices we were giving, offer testing to employees. Now, when we say provide testing, that means not making people take a test, but making people aware that they could take a test. Since it's at your cost, you also get to direct them to free sources of testing, but realize you're going to have to pay them for the cost of any out-of-pocket of the test, as well as their time to get tested. But it's an information of you may want to be tested, or you can get tested, or testing is available. If an employee, now then there's another area of notice, and this is a notice to Cal OSHA. If an employee is hospitalized due to COVID-19, and this has happened for several of our clients, you need to notify within 8 hours the local office of Cal OSHA that you have a illness. Now, this does not apply if it's clear that the infection did not occur at work. But if they're taken from work to the hospital, regardless of the source, you need to report to Cal OSHA. Also, all Cal OSHA cases, whether they're work-related or not, need to be reported to your workers' comp insurer within 3 days. Good news is all the workers' comp insurers that I'm aware of are quite experienced now in dealing with this and can handle it very well. And you can do so without fear because Cal OSHA, I mean, if the workers' comp system does not count against your experience any COVID-related cases. Another type of outbreak is a mass outbreak. I didn't mention, but in the case of 3 or more outbreak within 14 days, you need to notify the local public health agency. You also would need to notify the public health agency if you have a mass outbreak, which means more than 20 or more people in a workplace within a 30-day period. So and we have now had employers of our clients who have reached the mass exposure, mass case situation. At that point, you need to offer the COVID testing twice a week or more frequently, but no local health agency I know of has recommended more frequently, to people who were in the exposed workplace for the 30-day period from when the last event occurs. And a major outbreak is over when there are no new COVID cases for a 14-day period. When an employee has been subject to COVID, meaning close contact with a person within 6 feet or more within for 15 minutes in a 24-hour period, all this arithmetic becomes critical. You need to provide them information on how they can obtain testing, offer testing at no cost to them, and pay for their time taking the test, and protect the confidentiality. But your employee doesn't get to decide which test or where they want to go if you have a place designated where they can go. So in addition to the COVID issues, we need to realize we're still employers and have other laws. So we've had an increase in minimum wage as of January 1st. The California minimum wage has gone to $13 an hour for smaller employers and $14 an hour for employers with 25 or more employees. So this is important for 2 reasons. Number one, for the amount of pay per employee per hour. And second, if you have salaried or exempt employees who do not obtain overtime but are just paid a flat salary. To qualify as an exempt employee, the employee has to be paid 2 times the minimum wage. So that means for smaller employers, a minimum salary of $54,080. And for larger employers, 58,240. This kind of creeps up on you because you may be paying attention to your hourly rate, but have you adjusted your salary? And it may or may not be worth it to have a person be exempt any longer. This is an issue that you need to talk about, and your HR consultants can help you with. If you want to see local jurisdiction increases, and there are cities and counties all over California, including Los Angeles City, Los Angeles County, Long Beach, Malibu, Pasadena, and so on, they have their own minimum wage orders. Some of them went up January 1 as well. Most of them are scheduled to go up July 1 of 2021 next. But going to the website of www.epi.org/minimum wage tracker, you can get a review of what the jurisdiction minimum wages are. Now, some people have asked us which laws apply for minimum wage. And the answer is the higher minimum wage, depending on where you work. Even if your office is not in LA, if it's in Orange County, if you employees work 2 hours or more in Los Angeles, the Los Angeles minimum wage applies. The exception is if they're driving through LA and only stop to get gas, that doesn't count for working in LA. But if they have business meetings or call on customers or do deliveries, the LA ordinance or the jurisdiction wherever they work is going to apply. Also like to remind you about the independent contractors and ABC test. This was a test that was part of a California State Supreme Court decision, became a law 2 years ago, and was amended in 2020 and is now in effect, where there are approximately 80 exemptions from whether someone has to be treated as an employee or not. This is not an area you should take for granted. And I still have cases of employers who didn't think about it and just treat people as independent contractors, or sometimes they call them 1099 employees. You really cannot take that risk. You need to make sure that you know what the rules are. And if you want to have them be an independent contractor, you have to have a written contract, and the contract has to have terms that comply with law. So you do need to just check out and make sure how you're treating people if you're not treating them as employees. Carefully review anybody that you're going to be giving a 1099 to see if they qualify as independent contractor. Now, just last week, the state Supreme Court ruled that these rules for status of an independent employee or employee or independent contractor are retroactive or go back at least for 4 years, because for wage and hour violations, their liability as an employer can be up to 4 years. So retroactivity is now part of this compliance issue, something to be aware of and to take steps about. Another part is a change in the workers' comp law on what we call a presumption. And we could have talked about this under the COVID issues, but since it's a law that's in effect, I want to just remind you, if you have healthcare workers, peace officers, firefighters, or the first responders, or emergency workers, there's a presumption if they have workers COVID, it's going to be covered by workers' comp. Other employers, which include manufacturing, service employees, and so on, first of all, have to have 5 or more employees for the presumption to apply. And it applies when a COVID outbreak occurs. To make life difficult, the definition for outbreak under the workers' comp law is not the same as under the Cal OSHA rule or the stay-at-home orders. The definition for workers' comp liability is 4 or more employees, and is also or 4% of a workforce for a larger employer. But the most important thing for employers is to know that the new law requires you to notify your workers' comp insurer when you know or should have known an employee has tested positive for COVID. And this doesn't matter whether it's work-related or not. The notice requirement is a clear notice obligation. And employers need to watch about how they monitor absences when people miss work, how to handle people who may have had exposure or tested positive for COVID. because sometimes you don't know. Another issue is requirement for the employer providing training, and training for employees who have employees under age 18. This law doesn't apply to employers who have only older employees, meaning people 19 or older. But if in your workforce you hire people age 18 or younger, under the age of 18, excuse me, you need to train someone in your HR staff or your organization about the risks and dangers of child abuse and neglect, because they can become what we call mandatory reporters. And that means the need to report to social service agency of your area when you encounter a child abuse situation. And they could be the child that works for you. That's why you need to have this training. Also, don't forget that sexual harassment and bullying prevention training is still required. The requirement for training all employees for 1 hour applies to employers with 5 or more employees, and the training should have been completed on 12/31/2020. We know many employers did not get that done for a variety of reasons, including the fact that training became very difficult at the end of last year because of the coronavirus stay-at-home orders. So if you haven't done the training of the 1 hour for all employees, or the 2-hour training for supervisors and managers, plan on how you're going to do that and get it done and scheduled. The reason that's critical is if you have a complaint filed against you for sexual harassment, hostile workforce, abuse, and you have not done the training, you've set yourself up for a major increase in the penalties involved. There's no reason to do that. This is a requirement. It's been in effect for a few years. The deadline has come and gone, but that does not mean that there's an automatic penalty for not training. The penalty comes if you have a complaint filed and you have not done the training, or you're subject to some government inspection and they ask for your records and you haven't done the training. Another provision, and this is one that will affect many, many employers. Anybody who has more than 5 employees needs to be aware that the right of an employee to have unpaid time off for up to 12 weeks a year now applies. And that means if a person has to have time off for their own illness or to care for a family member, they need to have the ability to have unpaid leave, but you need to carry their health insurance as for them as you have before. There was a change a year ago where we had so-called baby bonding leave for employers with 20 or more. That isn't really applicable anymore because it's covered under the law that covers people with 5 or more employees. Now, if you've had more than 50 employees all for years, you probably are aware you've been complying with what we call the Family Medical Leave Act, or FMLA, and the California law, which is the California version of that, is CFRA. Up until now, those have basically been identical, and they applied the same rules and interpretations and applied to employers with 50 or more employees. The federal law is still the same, but the California law is different. And even if you are a large employer with more than 50 employees, you need to be aware that, first of all, the eligibility to take time off to care for family members includes more people under the California law than under the federal law. Surprise about that. But also, it applies to all offices because the old law says it applied to a company that had 50 employees working within a 75-mile radius. Well, since the law applies to employers of 5 or more, that didn't make any sense, so that rule doesn't apply either. What it really means is if you're a smaller or a larger employer, you need to take a look at your employee handbook and policies and make sure you and your supervisors know about this new law and what it means for you. It is not particularly burdensome, except that to take advantage of the law and to protect your company, you need to have some documented procedures, including when a person starts to take leave and why they're taking leave, and you're having a record that you gave them notice for how long the leave was and when they needed to come back and what the consequences of failure to return are. This isn't usually a problem if you have a good employee and they're gone for a while and you're happy to have them back. Those aren't the cases that we have difficulty with. The difficulty with the employees who go off and you don't know why, and they seem to be off for a long time, and now all of a sudden it's occurring to you that they want to come back or you want to replace them, and you don't know what the status is. If you haven't followed the rules and given people written notice, you're vulnerable for employment lawsuits if you don't let the person come back to work when they want to come back to work, which is not a convenient way for many companies to run their business. So you need to think about how you handle leaves of absence and notices and recording the time. There's also a new law regarding settlement agreements. If you have an employee who leaves and you want to avoid the risk of a lawsuit or complaints, you can have a settlement and severance agreement with them. And often prior to now, we had a no rehire, because if we were going to pay money to resolve disputes with the employee, the last thing we needed was to have them come back to work and start it all over again. The provisions of the law now prohibit the no rehire provision generally, with the exception of certain bad actors regarding sexual harassment. So if you use severance agreements or waiver of claims agreements, somebody should review it to make sure it's current. Also, we've made a change in the reference for crime victims and their leave, and the provisions are a little technical, and it also applies to family members' need for time off. We suggest you have somebody update your handbook and make sure you have a current provision that deals with victim leave. And another law requires, and this is now something that if you're a larger employer that have over 100 employees, you should have and likely have been filing with the federal government a form called EEO-1, which tells about the makeup of your workforce. Now California has a similar law that requires filing of a form about your workforce. And it applies to private employers with 100 or more employees. And you have to identify wage information by race, ethnicity, and sex. And each of the categories in the EE federal report, and also other data that's used for labor statistics. Be aware that these forms can be used to prove discrimination on pay based on sex or ethnicity. More likely than not would be a claim of unfair wages based on sex categories. And if you have multiple establishments that have 100 or more, you have to file multiple reports. So this is a new requirement, and most employers who haven't done this before need to be aware that it's an obligation. I hope I've covered areas that are concerned to you. We've tried to cover the key important issues for compliance. Please let us know if you have questions, and you can email me at dondressler@calworkssafetyhr.com. Or if you need any information, as Jake said, you can send it to info@calworkssafetyhr.com. And we have a few minutes for questions if people have some questions that have come up.
Yeah, let me go through the questions real quick. Okay, so let's see. What is the rule for lunch breaks and masks?
Okay, people are required to wear masks at all times unless they're actually eating or drinking. And when they're eating or drinking, they need to be socially distant. So they need to be 6 feet apart during the lunch break when they're not wearing their mask. So the mask rules apply, but there's an exception. When you're putting things into your mouth, you don't have to have the mask on. You don't have to have a straw that goes through the mask. But you also have to be sitting 6 feet apart from people. So the idea of going out and all sitting in a huddle and talking together and eating, unfortunately, this isn't the time to be doing that.
Okay, providing notice. Is this a letter to each employee, or can it be a brief notice with a sign-in acknowledging that they've been notified?
It can be anything that works. So you can have, but just putting up a poster on your bulletin board is not going to qualify because there isn't any evidence that people saw it. So having a single notice that people sign is appropriate. You can also use email or text messaging. So whatever is an effective way for you to communicate and realize you have about a day to do this notice.
Can a call or text meet the criteria for notifying?
A call doesn't qualify because there's no evidence that it happened, but a text message certainly would qualify.
We are struggling with the 10-day isolation for employees who travel outside of the country. Are employers required to force isolation whenever employees notify them that they have traveled?
Okay, the law itself does not apply to employers on travel. It applies to the travelers, the employees themselves. However, if you have a written COVID policy and you've dealt with employees who travel in that policy, which is entirely possible, then you need to enforce your own policies. So the first question is, what rules do you want to have for employees? And this is an area that also is one that's changing because we have now a ordinance of people traveling into LA other than from immediate Southern California counties are to quarantine. There's also quarantine orders in the San Francisco Bay Area. Um, and there's a general state rule about not traveling except for essential business. So the place to look is your own COVID policy and realize as a basic rule, employers don't have to, they're not liable for the violation of the travel policy. It's the employee who is liable. But you want to be sure you communicate with it and be consistent with your own policies.
Please define the difference between independent contractor versus consultant.
Well, here's the difference. You either are an employee or you're not. So if you're an employee, you have to be paid a salary. You have to have time records be subject to whatever overtime and wage and hour and discrimination laws apply. Consultant, by the definition, would imply somebody who has their own business who comes in to work for you. There are, as I said, 80 different exceptions. So if you're using people that you want to consider as independent, meaning consultants or don't qualify as employees, check it out. What are they doing? How are they doing it? Because certain occupations and activities or certain things done in a certain way qualify for an exemption. And there's so much complexity in this, I don't really want to be more general than that, other than to say, this is time for a quick phone call or email to have someone confirm what you're doing. And just because you've been doing it for a couple of years is no indication that what you're doing is legal.
Yeah, if an employee is willing to COVID test within 5 days of returning from a vacation or time in another country, does having a negative test waive the isolation period?
If for traveling purposes, it can. And in fact, some of you may be aware, international travel often today requires a COVID test before travel and upon arrival at the other's destination. So for people who are involved in particularly airplane travel, there are more rules that apply often from the airline itself or the airport or destination that they're traveling to. Um, as a general rule, a negative test is not an automatic pass on the requirements for quarantine. And the reason for that is many of these tests, at least certain types of tests, have about a 50% accuracy. So you could test negative and still be positive. Now, there are other more accurate tests that can be relied upon. But the problem is just relying on a negative test and ignoring the quarantine rules is not a smart idea.
With this Leave Act, if we pay 90% of medical insurance and the employee pays 10%, are they still responsible for their 10%?
Yes. And then that kind of creates an interesting problem. I know clients that have had difficulty with this because if you advance that employee 10% and they don't come back to work, how do you get your money back? Because there's no wages to withhold, and you cannot withhold it from someone's last paycheck. So you can require them to pay their share of the insurance, and you can require them to pay it when your own premium or eligibility notice is due to your insurer. So if you have to report somebody by the 10th of January for January coverage, the employee should have to pay you his share or her share by January 10th as well, so that you can take them off the eligibility list and your cost if they're not complying with paying their provision. Many employers have kind of let that slide. It's easier to just handle it and then try to recoup it. Problem is, it can be difficult to get paid back that money if the employee doesn't return to work and have pay for you to withhold in the future.
You mentioned that COVID-19, if work-related, wait. COVID-19, if work-related, are to use PTO, SDI, UI, etc. What about workers' compensation? Will they pay for work-related claims?
If you have a case where if you have 5 or more employees during an outbreak, then it's going to be a workers' comp benefit, or if you're an emergency responder, or if the case was last year, because the rules before the legislature made the change in the workers' comp laws did not limit the application to size of employers. So this is one of those areas, since you're supposed to notify your workers' comp insurer for anybody who tests positive, this is an excellent time for you to let your workers' comp insurer know and have them guide you, because they will have questions. They don't want to pay a claim they're not supposed to pay either, but it can be workers' comp can be a benefit that will cover the obligation. That's right.
If we had over 100 until March 14th, but under 100 for the rest of the year, do we still need to do the EEO one?
I don't know that. Send us an email and we'll look into it and get back to you. I suspect no, but I'm not going to guarantee that until I check that out.
Regarding Cal OSHA emergency temporary standards, if there aren't any monetary penalties for noncompliance, what are the consequences for noncompliance on January 21st?
Well, the monetary penalties for violating the Cal OSHA standards, there are penalties after February 1, and the penalties can be of 3 or 4 types. It could be a regular or a general regulatory or general violation, where the fines start at about $3,000, but often are actually in the neighborhood of $500 per violation. If there is a serious risk of illness, it can be a serious violation where the fines are $24,000, but are commonly levied for $18,000. And if the employer is ignoring the rules, for example, doesn't have a mask policy, doesn't do anything to educate his employees, then it can be a serious and willful violation. And the penalty can be up to $124,000, which is really not worth the risk. You don't want to get a serious and willful violation. You want to make a good faith effort to comply, which will protect you from serious and willful violation. But some of the meat packing companies you may be aware of have been fined, and the average fines for those employers for violation of COVID rules have been $50,000 to $180,000. So this is not an area where you want to take a risk.
How do I know when it is my business's turn to get the vaccine? We are an essential agriculture business in Los Angeles County. What type of documentation do we or my employees need to provide?
Frankly, the biggest issue right now is availability of the vaccine, not who's eligible. We have the rules in LA, as I understand it, are healthcare workers and workers of critical care and home for the elderly and people over the age 65. even though food and agricultural workers are entitled to status under that category as well, the county doesn't have enough vaccine to include those. It is likely that we're going to have touch and go supplies, and you're reading about this in the news, until at least the end of February, perhaps March, because even if some of the new AstraZeneca and so on vendors apply to the Federal Food and Drug Administration for authority to use their vaccines and it's given, it's my understanding that those manufacturers don't have large supplies already on hand. So the best thing to do is to check with their two sources, your county or your local public health agency and their website. If you have an insurer that deals with a healthcare organization like Kaiser or Hoag Hospital or Mission Hospitals, they're very active in trying to obtain vaccine and make information available to their clients or patients. Otherwise, you can go to ca.covid-19, which is a California COVID website, which can give you a direction to how to find information. This is going to be our biggest challenge for the next 6 to 9 weeks, is just availability of the vaccine.
Aren't monetary policies until February 1st? Then what are the consequences?
Well, for Cal OSHA, as I said, it would either, the minimum fines are likely to be $500 for a minor regulatory or general violation, up to $18,000 or $24,000 for serious violations. So you should definitely, number one, have a hazard inspection and have a record that you have. And number two, have a written COVID plan. And number three, prepare notices for your employees when somebody reports positive for COVID, so you can give them the notices that are required. And the good thing is our team have developed some sample notice letters. They're available to you if you request them.
If one or more employee works at various field sites that change from day to day, do we need them to do daily temp checks?
My suggestion, and it's the recommendation, first of all, it says whatever it says in your COVID policy. But the CDC guidelines and the recommendations are you have some process for checking people in every day, whether it's a text message, a phone call, an email, a questionnaire. You don't have to necessarily take their temperature, but it is important that you have some way of regularly keeping in touch with your employees. The consequences of not doing that are the employee is exposed, maybe even becomes positive, and goes 2, 3, 4, 5 days before you know about it. And now you multiply the number of people they become in contact with.
If you have to notify workers' comp of a positive case, are you meant to post on required postings in public?
You don't have to know the posting, and I'm glad you mentioned that, the Cal OSHA 300 work injury summaries have to be posted. You have to keep them within 7 days of an incident and post them between February 1 and the end of April. Recording of a COVID case requires it to be, number one, work related, and number two, a new case. And there are certain other elements we go through when we do the recording. So a non-work related COVID exposure is not required to be kept on your OSHA log 300s and so on.
And that looks like we are caught up on the questions unless we have any more.
Okay, I have one request for the audience, and that is this is the third month now we've done we call Third Thursday webinars. We're planning our sessions for February, March, and April, and we'd like to make sure that we cover topics that are of interest or helpful to you. So if there's some concerns or areas you'd like to have us explore on these future webinars, we would very much appreciate an email, either to info@calworksafety.com, or to me, so that we can make sure that we're bringing you helpful information that's current that you can use in your business. Thank you very much.
Thank you guys for attending. Stay safe, healthy, and have a wonderful day.
Thanks, Dawn. Appreciate it.